Okay, welcome IFA friends, and thank you so much for joining us today. We are very happy to bring you today's rapid reaction webinar entitled Potential Impacts of Possible Vaccine Requirements. How's that for the most qualifications in a single program title? But in more ways than one, that title accurately captures the moment here, and we will get into all of that and the questions therein in a moment. Today's webinar, of course, is a rapid reaction to last week's announcement by the Biden administration that the federal government is developing a standard to require all private employers with at least 100 employees to ensure their workforce is fully vaccinated or being tested weekly for COVID-19 before coming to work. So, but beyond that headline, there may be more questions than answers, and that's what today's program is designed to help you understand. So, a few announcements before we introduce our two great friends and speakers today. First, today's webinar is being recorded. The recording and slide deck will be available on IFA's community site later today. Second, and we will follow up with an email to all attendees as well. Second, we will take questions from the audience at the end of this program. We mentioned that there are certainly a lot of understandable questions. You can enter your questions at any time during the program through the chat function on your screen, and we will pose as many of them to our experts as we can at the end. And third, this program was marketed to last a full hour, but in all likelihood, we will not take all that time today. Okay, first, let us introduce our two speakers and then turn it over to them. We have our great friend Tam Kennedy, who is a franchise owner for Taco John's restaurants, specifically Twin City TJ's Incorporated. Tam is an IFA board member, a franchisee forum leader, and certainly a great friend of the program, and we're excited that she can join us. But first, we will turn it to Jim Peretti. He is shareholder at Littler Mendelson. Jim is a longtime Capitol Hill and executive branch staffer and counsel, and Jim is a great friend as well. So before I turn it to Jim, just two disclaimers at the start of this program. And first, and Jim will make this point, I'm sure, but wanted to stress it at the top, there are very few details about the requirements that we're going to discuss today. So we just ask for your grace and understanding about what little hard information there is to work with at present. And second, this is a COVID program. And so as with all things COVID, we all want to stay safe and keep our people safe. We want to acknowledge that. But beyond that, we should probably all acknowledge that we may each have different COVID concerns and comforts, and all of the sub-issues within COVID are pretty touchy these days. So it plainly takes some courage to wade into these issues in any public setting. So I say all that as an extra thank you to our speakers, Jim and Tam, for sharing their expertise today. So again, Jim, thank you for joining us today. Let me turn it to you to share where we're at and what we know at this hour. So welcome, Jim.
Sure. Well, first, my pleasure to be doing it, Michael. Always good to talk to IFA, and I will share my rapid reaction, which was, like, really one more thing thrown out as, it's like we were fine every time we think we're getting the knack of it, or we think we're on a course, or we think we have a plan, something comes along and scrambles the deck. So we'll go to the first slide, or next slide, please. And I'm just going to briefly recap where we are. So last Thursday on September 9th, the White House took, there's actually 3 executive actions. I'm going to talk briefly about 2 of them. One concerns the federal workforce, not really going to be our focus here today. But there were 2 federal actions that President Biden took last Thursday. One was a formal executive order addressing vaccine requirements for federal contractors. These are contractors with 100 or more employees. It covers all but not every federal contract. So that if you do contract with the federal government, you're going to want to get with counsel to see if you fall into one of the categories. It is not the same universe. It's a broader universe of folks who may be subject to affirmative action plans or be within OFCCP's jurisdiction. The universe of folks subject to this vaccination requirement is a slightly smaller universe. Also, we're going to get additional guidance. The executive order directed additional guidance on September 24th, by September 24th. And I raise the issue only because with this one, we actually have something resembling more of a legal document. This is the executive order. It's requiring OFCCP and the acquisition council to do X and Y and Z. The president also announced the private sector emergency temporary standard for private employers with 100 or more employees. On that one, we don't have a formal executive order. What we have, honestly, is drawn from a few White House fact sheets. It is drawn from comments in the press. It is drawn from a late Friday Department of Labor briefing where certain questions were answered. A lot of questions were left unanswered. So we are digging into this. And frankly, you know, the short takeaway has been, well, employers of 100 or more will need to vaccinate or either need to get proof of vaccination or do weekly testing. But OSHA actually has a lot of leeway there, depending on where they want to go. Can I get the next slide, please? Just putting this up there on the screen. I know you mentioned the deck is going to be sent around an email. We are at Littler publishing things as quickly at the speed of sound as we can. Within a few hours of Thursday's action, we had this document up, and this sort of lays out everything that we know about current actions to date. I expect before the end of the day, we are going to be updating that with, again, some of what we'll talk about here, which are things we don't know. But I just wanted to put that there to folks. If you go to littler.com, and I think it's the news and events tab or something at the very top of the site, you'll see our publications on this. And these COVID ones are usually generally high to the top. So if after today's webcast, I haven't answered things or you're not clear on something that I said, chances are you'll find what the answer, to the extent there is one, in that document. Next slide, please. So what do we know? We know that currently the president has directed OSHA to come up with an emergency temporary standard. We expect to see that, you know, usually these things can take 6 weeks, 8 weeks, longer. I think they're going to try to do it sooner rather than later, but I think it's going to be at least 3-4 weeks, if not longer than that. You know, the general consensus, what we're reading in the press, is that OSHA learned about this no more than a week before the president announced it. So it's not a situation where they've been working on this, you know, it's 80% done and they're just putting the short strokes on it. I think they're starting with a lot of blank paper. It will likely be a temporary standard. That means it will not be permanent and in effect forever, but it will become effective upon its issuance. There is no comment period prior to its issuance. I think when asked about that, OSHA said, we've been listening to stakeholders for 8 months. We think we know what we need to. The standard will come out, it will become effective. I imagine there will be some lead time before, you know, I don't think it's published on Monday, effective on Tuesday. So there'll probably be a little bit of lead time. And then there will be a comment period to address questions. We will not have the opportunity to formally weigh in, although we will be working through Littler and the Workplace Policy Institute, which is sort of our policy shop. We will be trying to do informal work with the department and with other stakeholders to make sure issues are brought to their attention. There's nothing that prohibits us from saying, hey, when you do this ETS, think about this, think about that. Here are lots of questions. One question folks have asked a lot about is, you know, how are we going to count that 100 employees? And that deal has been fairly clear that it will be per employer, per business, not per work site or location. And as Tam starts to, and I start to get into some questions, we can talk about what that might look like in various contexts for franchises. The other thing that they've made clear is it will not apply to remote workers. But again, we don't know yet what that, you know, how that's going to be applied. Is that someone who, if your job is 100% telework, always has been prior to the pandemic, during the pandemic, pretty clear that's going to apply to you. But if you're someone who shifted to remote during the pandemic, but now maybe wanting to come back, or your employer wants you to come back, you know, that's that too. The contours of that are not yet clear. So with that, I think next slide, and I'm going to flip it to Tam to start to, we'll play a game of what we call Stump the Chump and talk about what we don't know. So
awesome.
Tam,
Jim, thank you. Jim, thanks so much for that. Very good information. That speaks to sort of how little we do understand at this point. So we, as Jim mentions, we do want to bring in our friend Tam Kennedy to share a little bit about the business perspective, the franchise perspective here. So Tam, thank you for joining us. I know you're not on video today, but please, if you'd like, share a few thoughts of sort of top line where you're at, and then we can get into some of the other specific questions you have outstanding right now.
Sure, absolutely. Well, good afternoon, everybody. Thank you for having me, Michael. Great to be with you as well, Jim. Not unlike everybody else, kind of did the freak out when the announcement was made. I think because there's so much of unknown to this announcement than there is known. And really, how does that manifest kind of, as I always say, on the street, right? So we've got, we kind of always have felt that from a franchisee perspective, we are a slave to many masters. We certainly are good community partners in following rules and regulations, federal, state, and local. That's part of being a business owner. We also, though, have a special mandate to comply with what our franchise brands come up with in terms of protocol, system, structure, all of those things. And then we add another layer by taking on, I think, the awesome responsibility and honor of being a small business owner and how we reflect that in our workplaces. And so as soon as the announcement was made, I thought, okay, this is kind of a storm here. And how an individual owner responds to it is going to be, I think, really, really important that we focus on making sure we kind of thread this needle with what is our responsibility from a compliance perspective, but what also is our responsibility to our employers and our employees and their families, and to each of our communities. And so I fired off, and you all of you that know me on the call know that I get pretty excited when there's some challenges out there that I think we need to respond to. I fired off a really long email to the leadership team at IFA with a lot of questions. So I'm going to ask some of those today. Jim's going to do his very best to try to help us navigate some of kind of the unknowns as best we can. But I really come to this discussion today with this idea that there's a lot of downward pressure right now on businesses. We've got labor shortages, we've got supply chain shortages, we have what I call tension in the workplace, a lot of tension. And it's manifesting itself from our employees to our customers back and forth. And you're seeing it as well, franchisees and brands. There is tension. And this action has not helped. This action is going to put individual owners in some really tricky, kind of troubled waters in terms of how we respond, but very specifically the steps that we take to respond. So let's start with that. Jim, I'm going to maybe just ask you some questions. The first one's popping up on the screen, but when we say how will the employer require a COVID vaccine? Particular for me is if I have an employee manual that doesn't talk about medical issues or doesn't, says that we'll give you notice when we make a change to the policy manual. If this is to become a policy, a standard workplace policy, how do I require it without giving it back? Like, what does that really mean for me? Do I have to notify everyone?
Yeah, I mean, and I think maybe the ETS will speak to this, maybe it won't, but I think if you start with the premise by saying, okay, am I going to be a covered employer? If I'm a single franchise owner with 50 employees, chances are I am not going to be covered under this. And we can talk about how they're going to count to 100 and what that means for franchises. But let's say for the sake of argument, you're a single franchise owner with 200 employees, and you say, okay, I am now subject to this. I think if you don't currently have a policy in place, what you probably want to do is work with counsel to draft. It doesn't have to be lengthy, but a short policy saying, pursuant to federal regulation, as of X date, as a condition of working on site, you'll be required to show proof of vaccination. This leads to some questions about, time. You've asked what you're going to have to do, but it's also going to be questions of timing in this ETS. Because the current vaccination regime, to be fully vaccinated can be as little as 15 days if you get a single shot of J&J and you're fully vaccinated 2 weeks after, or it can extend to something closer to 42 days, where it's, I think it's Moderna is 4 weeks. You get your shot, you get your second shot 4 weeks later, it's 2 weeks after that you're fully vaccinated, that's 6 weeks. where, and DOL was asked this question and they did not yet have an answer, that, will proof that I've gotten the first shot be sufficient? Do I have to have proof of, as an employer, will I have to see proof of both shots? Does it have to be 2 weeks after that? But I think once we see the terms of what they expect of employers, you'll want to adopt a policy that says, as of this date, this is what's required. You need proof of vaccination.
Right.
Maybe now's a good time to just flag an issue too, which is it's really being reported as OSHA will issue a policy whereby all employers must either get proof of vaccination or test their employees and get negative test results. I think looking at the scant information we have available to us, that's one way OSHA may come down here. OSHA may also come down and say, as an employer, you must have proof of vaccination. And if you choose, you may allow your employees to, as an alternative, do a weekly test. But it may be that as an employer, you're not required to allow your employees to test out. We just don't know what that's going to look like. But those are
Right.
two very different, practical, on the ground structures. One, if it's vaccination or no work, versus vaccination or test or no work, those raise two very different sets of challenges for employers.
Correct. And I'm going to back this train up just a little bit. You said ETS, Emergency Temporary Standard.
Yeah.
Tell us what that is. Tell us what OSHA's, how OSHA is, what is it? It's a 50-year-old on the books kind of product, a tool that they can use. Tell us a little more if you can.
Sure. Yeah, and Emergency Temporary Standard it's a regulation. It carries the force of law, force of regulatory law. What's different is, whereas most normally a regulation is proposed, there are comments, the regulation may be changed, it then becomes final, it then goes into effect. Here, what they will publish is something that will go into effect immediately, at least on the date of publication, but as I expect, there will be lead time built within that. Then they'll take comments subsequently. It will be a challenge for OSHA, to be honest. I mean, it has not used its emergency temporary standard powers frequently in the 50-some years the Act has been around and the agency's been around. You need to show that there are grave danger to the workforce, justifying these, new emergency rules. Some have suggested that the Delta variant notwithstanding, 18, 20 months into a pandemic, it may be difficult to show that we're in grave danger. So that's the legal challenge that OSHA will have to jump through some legal hoops, including establishing a record to justify why it feels its emergency powers are justified in this instance.
Gotcha. That's good to know. I think when we hear what's coming, we want to know who's saying it and what their authority is, and then how, kind of how that whole piece forms out to come down as an actual mandate or an actual regulation. I think we talked about is the right word, a regulation. It is the word I think a lot of people are keying on, and hopefully when we close here, you'll share a little bit more about the word temporary and what that actually could possibly mean to all of us. But let's move on to the next question then. So how will we require it? We'll require it based on using a series of procedures that we'll put in place to make sure that we're covered to do that. So vaccine, got it. If the COVID test does make the either or with the OSHA ETS, how do I provide for a COVID test or a COVID test? This is a big one here. Am I supposed to, starting next week or later this week, I can order at cost through 3 major systems COVID tests, rapid tests, and I can administer those tests, or technically I can hand them out to be self-administered. What does this mean? How does an employer provide a COVID test?
Yeah, I don't know that the employer is, well, let's say either the ETS says you must allow for testing as an option, or you may allow for testing as an option, but the employer says, yes, for a lot of reasons, I'm going to allow for testing as an option. I do not think that OSHA is going to say that the employer must provide the test itself or administer the test. It may be sufficient that the employee, a scenario you described, which is we are providing take-it-home rapid response tests to employees who are not vaccinated. at our expense, and we expect them to take them and, you know, certify that they were negative before coming in. That is one option. There is, alternately, I'm in the middle of Washington, D.C., and if I look down into the park outside our office, there is in D.C. a rapid testing center that if you want to walk up free of charge and obtain a test, they will test you, and you'll get your response in 15 minutes. I think the ETS will probably spell out what are the various ways that an employer can satisfy this requirement if it goes this route. But there are going to be a lot of questions about that. Who pays for it? Who pays for the time getting tested? If you're an exempt salaried employee, that's one thing. If you're a non-exempt employee, an hourly, and you are testing, if the employer is requiring you to test, if they're allowing you to test, ton of wage and hour issues there that I don't know that we're going to know the answer to. And even, you know, OSHA has certain authority to say you must do this, you must do that, but OSHA, there are lots of things OSHA doesn't have authority over. So even if OSHA said, for the sake of argument, employer must look at a test result, the employer does not have to pay for the test, the employer does not have to pay for the testing time, says OSHA. Well, that's great, OSHA, and maybe even OSHA speaks for the Department of Labor. That's great, Department of Labor. That gets us out under the Fair Labor Standards Act. But for those of us who are operating in the state of California, you know pretty much that if your employee, you know, gets a piece of food stuck in their teeth at the company picnic, you probably have to reimburse them for the toothpick they used to take, you know, to jiggle the corn out. So,
Right.
You know, OSHA can't wave a wand and get rid of those requirements. So here's one. That's a lot of unanswered questions.
Yeah. And to the next question that's going to pop up as we think about this too. So we don't know what we don't know, but we do know that in the White House press briefing on Friday, it was said on behalf of the White House that the expectation is that small businesses can afford this. We can afford it. If you go back and look at the tape, you'll see that the idea here is that we will be able to afford doing this. Question number 3 coming up to you is, will employers have to pay for testing? Our employees, I mean, rightfully so, are going to look to us to say, look, I don't want to pay for any tests. If you're going to make me go get a test, it better be free or you're going to have to pay for it. And I can appreciate that conversation. A reminder to everybody that not every working community is urban. There are rural considerations here. It's not next door that you can get these tests. There's travel time. We spent the weekend thinking about the 30-mile commute that some people make from the country into kind of a county or a rural hub to get some of this stuff done. And so when we talk about, do we have to pay for the weekly COVID tests? The literature, I read the executive order, it says that we have to pay, the expectation is that we'll pay for their time off to get the test. And here's the big one that's not on your list, so sorry, Mike, that we will pay for any time off for a negative reaction. My question to you is, what if the negative reaction is 6 months in the hospital or a death? Because I mandated an inoculation. What do we do?
Couple of thoughts there. I have to look at it, and I'm gonna, if you've read it more recently than I am, you may be right that I know that. I think that what I recall reading was that the employer will have to pay for time off to go get the vaccination, and certainly give paid time off for any ill effect that comes from any side effect of the vaccination. It may be that it is already made clear that they will have to pay for the time to get tested. And I apologize for just not having, with my eyes on the screen, I don't have that bit of language in front of me. But your second question really was, so let's say for the sake of argument, at a minimum, you're required to pay time off to someone who goes and gets the vaccine, and then you're required to pay for any, symptomatic after effects of getting the vaccine. The good news with response to that question is, generally speaking, in almost all instances, the negative side effects to the vaccine have been, relatively short-term in nature, 1 to 3 days. It hasn't been, in most instances, that severe, terrible reaction to getting vaccinated that ends up in 6 months of debilitation or, God forbid, employee death. I would think, in the unfortunate and unlikely and tragic event that would happen, I think that would probably be looked at as a workers' compensation claim, to be perfectly frank. Again, I don't know that we've gotten anywhere to there yet. And we'll see what they say. But I think what's contemplated is, I got my second shot the day after. Did I feel great? No. Was I suffering in bed? No. But depends on who you are, depends on your health status, depends on which vaccine you get. We all know people who, oh my God, I got my second jab of blank Moderna or blank Pfizer. And for 3 days, I felt like I was down for the count. I had a temperature, my flu was up. It lasted 36 hours, and then, everything was fine. I think that's what's contemplated, but we'll have to see.
Sure. So probably, all around kind of the scheduling piece of this, or the pay and the schedule and all of that, going back to the ETS, the temporary, there are mechanisms in place for reimbursement to business owners through kind of some of the COVID acts that have been passed, for paid time off for employees due to COVID kinds of things. So probably version 2.0 of this webinar will happen after OSHA releases kind of the standards, and that'll be something that, should we be tracking time off, all of that, in terms of what it's going to cost our businesses, and is there going to be a minimum maximum? So if one employee takes 1 day off, should everybody take 1 day off? That kind of thing. Those are all questions right now in my employee community, my team, that have already been asked. The question that always comes up is what's fair, and nothing really clears that up. We've all got some tight ropes to walk here on that. So why we're asking these questions, right? How do we manage the conversation? Next
Sure.
question. So can the employer request an employee COVID test result? We kind of covered that. If it becomes the mandate, yeah, we can request it. Here's what I want to know. Are we supposed to track it? Let's talk about privacy of records, and is it supposed to be the same day every week? How do we gather, collect, keep private these test results?
Yeah, I mean, it will be weekly. I don't know that it means Monday of every week is everybody has to come, everybody has to get tested on Monday and send their result into HR. I do think you want to maintain them as confidential medical records, unlike vaccination status, which at least EEOC has said it does not consider to be a medical inquiry. This is the result of a medical test, so you're going to want to maintain it in accordance with all of whatever state and federal protocols are there, but you're going to want to maintain it separately from the personnel file. You're going to want to keep it as confidential as is necessary. I mean, obviously, some people will need to know. A manager will need to know if an employee tests positive and is unable to come to work that week, or tests negative and is able to come to work. But
Right.
The manager of those employees needs to know, not perhaps not every employee on the shift.
Gotcha. And going back to, if they're in the middle of a series of vaccinations, a 2-shot series, depending on the type of vaccine they've chosen, we've got kind of that issue that needs to get answered in terms of, they've had one vaccination, they maybe haven't had the other one. Do I still need them to get tested until they get the second one? All of that. Do we expect OSHA to give us some guidance on whether or not what's considered fully vaccinated or this test? Do we expect to see that in their order?
I would expect so, particularly since this question has, it's sometimes when a standard comes out and someone asks a question, you say to yourself, oh my God, nobody thought of that question before now. Oh, shoot. This is one that I was on a stakeholder call on Friday where, DOL does these things. DOL, which is the parent agency of OSHA, the Department of Labor, they fielded questions from stakeholders. They offered some minimal answers, but I mean, they're on notice as of day one that this is a question. What does fully vaccinated mean? What does it mean for that sort of intervaccinated period? They indicated they did not yet have an answer on that, but it certainly, the way to me was that they will provide an answer to that in any standard that they put out there.
Agree. I was on the call as well, and it was a perfect setup for college football. There was a lot of punting going on Friday. It was really interesting. We don't have an answer. It was a great webinar of no answers, but important to know kind of baseline where we're at. All right, next question. Let's think about this whole termination piece to this. Can we terminate somebody if they refuse either of the two choices? And what does that mean for us as an employer?
Sure. I think OSHA, am certain, is not going to put, in bold type, if the employee doesn't take a test and if the employee refuses to vaccinate, you may fire them, no questions asked. They will not say that. I do think as a practical matter, if you have an employee who is, required under the standard to either show proof of vaccination or to show a test, and who refuses to do so, absent, and we can talk about, protected reasons, religion, disability, if it were that, I would look at this as a drug test potentially. If an employer refuses to take a drug test on where they're required to, can you terminate that person? Yes. Do you necessarily want to terminate that person in this instance with respect to COVID? Maybe not. It may be that you can put them on unpaid leave for some period of time. Setting aside all the legal, as a practical matter, we've had employers, clients at Littler, who were concerned, if I, Joe's electronics store, require all of my employees to be vaccinated, 75 of my employees are going to quit tomorrow and go work for Mike's electronics store where people don't have to be vaccinated. All things being equal, if everybody's playing under the same rules, that may or may not, that question may be a little less relevant if now I don't have the, it's when Jim says to his employees, hey guys, this wasn't my idea, the federal government's making me do it, and they're making a competitor across the street and my competitor across town do it, the option for the employee to say, hey, I'm going to take my marbles and go someplace where I don't have to do this, may be more limited. So we'll see. As a matter of straight up employment law, if you're required to get one or the other, can you terminate them? I would suspect, absent any other protected leave, all the other categories of things that we'd want to think about before you move to a termination. Ultimately, if they can't do the job, I think the answer is yes.
That said, making sure that we seek counsel, get this document prepared to give to our employees, giving them the notice that this is a new rule or a new policy that as part of their employment package. So we've got some work to do between now and then, making sure that they know the consequences. There's that whole piece, right? We need to inform before we enforce, I guess is the way I would say it. Okay.
Yeah,
okay.
I would absolutely. I mean, and listen, I'm doing this now in the absence of any federal requirement. We have clients who are starting to go to hard vaccine mandates. You must be vaccinated to return to work. If you can't work remotely and you don't have an accommodation for religion or disability, you can't work here. In some instances, that means in the retail environment, maybe I'm putting you on temporary unpaid leave until such time as the situation changes. In other instances, if you need to be in the office to do your job and we are opening next week and we can't do telework and you can't get vaccinated and you don't have a protected basis for doing it, that can be grounds for discipline up to and including termination. How you categorize it may be important.
Right.
I would not, terminate. I would not code it as termination without cause. You have potential WARN Act issues, not to go far afield, and maybe that doesn't affect too many folks, but we've seen those cases where, an employer was coding people who didn't get vaccinated or couldn't work because of COVID as no cause terminations. And in some instances, how you code it may be significant to what your layoff and notice requirements are. So,
right.
Tam, I think you stumbled on it, or didn't stumble on it. You made the excellent point that whatever you do here, you're going to want to get with your small business counsel and say, okay, here are the 10 things we have. Here's what our policy should say and do and look like.
Yeah, it's time for a review. I think for all of us, it's not something we probably have the time, had not budgeted time for to do like today. No one kind of really, I don't think we saw this happening, but it's going to be important that we pivot a little bit, make sure that we get kind of those ducks in the row, and make sure we track that we notified every single employee, make them sign off that they've received notice of a new change in policy. I think that's going to be huge, because there's always that I never knew it. You can't fire me. You failed to, you failed to inform. So there's that whole kind of thing that we need to do. So the folders are coming. All right, next question. So federal, state, and even local laws, will the standard conflict with other federal and state laws, particularly medical privacy, HIPAA, the record, all of those things? For me, this question is important because employees talk. All right. The bigger thing here is kind of like who you voted for. There's a few things we don't talk about in our workforce. We really try to limit discussion. As we say, let's talk about tacos and baseball. That's it. Tacos and football. That's it. We really don't want to get into a long discussion about, well, did you get vaccinated or didn't you? Well, I don't think that's fair. There are employees now in my group that want to know whether or not all of the people on their workforce today have been vaccinated, and they're demanding, I think, that we as employers start sharing that information. So let's talk about conflict, like with law.
Yeah. I think I'm not sure I'll say it'll conflict or there'll be conflicts. There may be places where it's inconsistent or where we're going to have to navigate two sets of facts at once. For example, you can encourage folks to not talk about certain things, but you could not absolutely prohibit someone from saying, okay, you were talking about COVID-19 and the company's response to the pandemic, and we're firing you because you were talking about that. You run into potential National Labor Union Act concerns.
Yeah, we would not do that. We would never do that. But what we want to make sure of is that we don't open up the records to our team. We don't. Right, no. Okay.
No. And early on, particularly back when we were back in May, and we saw that, or June, where we saw the good what I'll call the good CDC guidance that was starting to say, hey, for vaccinated people, you don't need to wear a mask. You don't need to do this. You can go to the office. You can sort of go about your business. We had a lot of employers starting to say, okay, we're going to start bringing people back to work. If you're not vaccinated, you have to wear a mask. If you are vaccinated, you don't. The plain fact of the matter is, in almost, there are many reasons why someone who might be vaccinated still chooses to wear a mask. Maybe they have kids at home. Maybe they have a compromised relative or elderly parents. But in some instances, it's going to be, oh, so-and-so is wearing, Jim's not wearing a mask. Jim plainly is vaccinated. It's your status is there. So it's, it's not as if employees are not dumb. Employees are not, able to look at what's going on and sort of make some deductions, but it's not your job to be telling employees what the status of their other what their coworkers are. It's your job to say, hey, we are doing everything we can within the law to provide a safe and hazard-free workplace for you. That's our commitment to you, and that's our job, and your job is to make the tacos or manufacture the X or provide the Y.
Gotcha.
So I do think where it's going to be interesting is, so it's been described in the media, oh, there will be narrow exemptions for medical and for religious reasons. Well, I can tell you, and those of you who have started, if any of you on the call have started with mandates, I can tell you, if they adopt sort of the current law guidance on where we are with respect to particularly religion, but also disability, but more so in religion, these exceptions are anything but narrow. And it is the issue that most of my big clients, my small clients are facing right now is we're imposing a mandate. We want to be good, equal employment, we're equal opportunity employers. We want to accommodate people with disabilities. We want to accommodate folks who have religious objections. But, suddenly 50 members of my staff over the weekend, found religion, and I have all these requests for exemptions sitting on my desk. Can I deny them? It is not, the sheer volume is a lot, and the breadth of what, at least under current guidance is protected in the EEOC's view is a lot. So I don't know if I'd say there's a conflict there, but I hope, I don't trust, maybe I pray that someone at EEOC is talking to someone at OSHA to say, hey guys, we're hearing that this religious exemption has caused a lot of, forget whether you think it's legit or not. It's just as an administrative matter, it is causing a tremendous hardship on employers to have to, assess these things and make decisions in response.
So you're right. So speaking of loopholes, last couple questions. Okay. Can an employer reduce its workforce to 99 employees to avoid the hurdle? I mean, it's a simple question. It should be a simple answer. Is it?
I think so. I don't know. I won't know until the ETS issues. I think OSHA would probably be going over its skis a bit. OSHA's job is to provide a safe workplace. It's not to provide a stable and secure a full employment workplace. If you had an employer who had 101 employees who said, hey, I'm going to terminate 2 for no, fine. I would never say find a reason, but I'm terminating 2 employees. Maybe it's the last 2 people who were hired, the 2 most junior employers, for the purposes of getting under this. I don't know that there's a legal prohibition on doing that. Certainly, if I were an employer sitting at 95 employees and doing pretty well, I think I'd take a look at this temporary standard and say, okay, how long do we think it's going to last? Will we know? I don't know that we will know on its face, but maybe if I'm doing fine with 95 employees, I say, let me push off hiring those next 5 until until Q1 of next year or Q2 of next year.
Sounds good. And I kind of figured that would be the answer. Is OSHA's not going to give us that guidance, but that is a troubling thought out there. Last question. It's not on the slides, but I'm going to ask this because I think that there's a bigger kind of more global perspective here. What if the franchise brand, the franchisor, mandates a position or delivers some messaging that really might affect a franchisee's ability to comply, or if there's a disagreement between the franchisee and the franchisor? Do we think that we're going to see activity where the franchisor is going to be enjoined with some of these penalty issues if a franchisee fails to comply?
I don't immediately. Again, OSHA can do many things. I'm not sure that they can get into the liability issues between a franchisor and a franchisee. If I were a franchisor, I think the position I would take is that I would require my franchisees to be in compliance with all applicable federal, state, and local law as applied to them. I don't know that I would be in the business of saying, as the franchisor, you must have a mandatory vaccination policy. What I would say is, and I'm sure it's in your contracts, I would be stunned if it wasn't, that franchisee warrants to be in compliance, much as you do with wage and hour law, with all,
right,
other state and local. So I don't know if I'm the brands, I'm going to go out on the limb and say, let's be real clear, we blank franchise, endorse this or that. I think the wiser, if I'm counseling a franchisor as an attorney, I'd say your course of action is your franchisees need to assess for themselves what their responsibilities are under these orders, and to be within what is legally required of them. And that's your job. That's your role as a franchisor.
Okay, and I think that's important. There are lots of franchisors on the call, and it's important to, you can talk about it from a corporate perspective, but our corporate friends, our corporate partners are people too. They have opinions too, just like the franchisees, our employees, and our customers. We all have opinions about this. So trying to sift through the emotional pieces of this and really focus on taking a high level approach to it, I think, is probably where a lot of the angst is coming from. So those are my questions. There are plenty, and I appreciate you taking the time to fire away on some of these answers. Mike, where are we at then on opening it up for Q&A?
Yeah, let me visit before we do that, let me visit one topic I want to just touch on briefly, because I know you guys, IFA, I know already you've been hammered with this question, which goes back to how do we count to 100? How do we figure out 100? I do not expect that the OSHA is going to come out and say, if Jim has a single unit franchise in Washington, D.C., that Jim's single unit franchise that employs 40 people, that Jim's single unit franchise is going to be combined with every other single unit franchise or every other unit franchise in DC or every other franchise nationally to determine that Jim, who has 40 people on his payroll, is now the employer, is subject to these employment requirements, as if I had 500,000 people on my payroll when you looked at the entire franchise network. I don't expect that OSHA will land there. I expect they will land that, what if Jim is a single franchise with only 40 employees? Jim is probably out and not subject to the requirements of the standard. The question will become more tricky if Jim has 6 unit franchises in the city. Each one of them employs 40 or 50 people. And there's maybe, there might be 2 answers there. One is, if Jim has 6 franchises, each franchise has its own general manager, separately incorporated, maintains its own books, its personnel work in that franchise, only in that franchise. That's one fact pattern. And I think in that fact pattern, you have 6 businesses that don't have 100. If on the other hand, Jim has 6 franchises, they're not individually incorporated, or they're all incorporated under one. I have managers shifting between locations. I have personnel shifting between locations. I have common, it's one thing for your policies to look similar. It's another thing for sort of all the HR to be coming from Jim and not from my general managers. I think that's a standard franchise, sort of joint employer analysis. Are you, it's almost like piercing the corporate veil. Are you really 6 separate companies, or are you one guy who's running 6 separate, 6 companies as one business?
Gotcha.
But we'll see. I think I don't know that OSHA is going to try to make new law there. I suspect they may, as I think we saw with respect to FFCRA, which was the leave law from last year, and some others, which is, under franchise rules and other things, there are standards for determining where you get to. But this is purely me spitballing, but I know it is a question that is on folks' minds. We're going to work with IFA to make sure that those questions are relayed to the agency in a way with answers that we hope will be the answers that we want. So with that, now I'm going to be quiet and let Mr. Lehman tell me what questions members have or what else we can do in the time we have left.
All policy, roads, and franchising lead back to joint employment, Jim. So thank you for addressing that question for us. A really good give and take, you two. Thank you, Tam, for posing all those insights and questions to Jim. And Jim, thank you for answering the unanswerable questions, which many of those are. And on that note, we want to we've got a whole host of questions from our friends on the line. We want to get to those. Let's go to the next slide briefly, because I have 2 public service announcements for this group. Clearly, this is an engaged group. We would ask everyone on this line, if you haven't already, to join the Franchise Action Network so that you are able to engage on issues like a COVID vaccine and testing mandate that comes out of the federal government. So if you simply text FAN to the number 52886, FAN to 52886, you will be a part of IFA's grassroots organization, so that you can help us weigh in and we can benefit from your expertise on these issues. And then if you're a member of FAN on the next slide, you also will have particular access to next week, our Capitol Hill Day of Action, on our virtual Day of Action on Wednesday, September 22nd. You can go to this site, franchise.org/events/fan, for more information. But even from your remote workplace or wherever you'll be next Wednesday, you can participate in IFA advocacy during this critical time in, candidly, American history next Wednesday. And we'd love to have everyone involved, and we'll have much more to send folks. Okay, with those 2 out of the way, we do have many questions. And let's start on the employee side. A lot of questions about the parameters of employees. Jim, you just answered the sort of joint employment issue question between franchisor and franchisee. You're cautiously optimistic, it sounded like, that all employees in a franchise system will not be aggregated together for purposes of the 100 employee threshold. We will see. You've talked a bit about non-exempt and exempt employees. Do you have expectation that both full-time and part-time employees will be covered here, though, Jim?
Yeah, the answer to that one, if I had to hazard a guess, I'd say for the threshold purpose of determining coverage, yeah, I suspect so. I think that would be consistent with what the Department of Labor did last year with, if you remember, you'll hear me refer to FFCRA. That was the COVID protected leave back in March. That continued through the end of the year. It's now on a voluntary basis, but if you got exposed to COVID, if you had to say, it was temporary paid leave that Congress passed, and it had their threshold was 500 employees or fewer. But for purposes of coming to that 500, DOL was counting heartbeats, not schedules. So I suspect if Jim has 90 full-time employees and 20 part-time, make it easy, 90 full-time and 10 part-time, half-time employees, I think Jim has 100, not 95. I don't think they're going to count FTEs. I think they're going to count heartbeats.
Okay.
Thank you. And then as far as 1099s, independent contractors, what do we think about them being considered employees in this instance?
and again, this is, I just have to caveat, this is all me spitballing and hoping and guessing. I think employee means employee. If you have 1099 contractors, and they are beyond a shadow of a doubt contractors, there's no question of whether they are independent contractors or not under the rule. I don't think independent contractors will count against your number. Where you have folks who are classified as independent contractors who might, argue that they should be classified as employees. I don't know that OSHA is going to say, let's start that fight right now, for purposes of, nor does OSHA really have the authority to, fight that fight. But I think it's a standard analysis, which is if we're comfortable that the folks we have classified as 1099s are in fact 1099s, you're not going to count. If you are in an industry, a franchised industry, and we can think of several, I'm sure, where the status of contractor workers has been an issue, you may have more to think about there. So I'll leave it at that.
Right. No, we've seen a lot of efforts to expand the definition of employee all around the country, as you know well, Jim. So certainly a good question that several of our guests on the line had. Remote workers, you mentioned, are not likely to be covered here based on what little we have, but any definition of what constitutes a remote worker in this?
Yeah, so no definition. Is that going to, as I said, the archetype of remote work? Things I learned during the pandemic is that call centers, which I always thought, were very often, and still are sometimes often big rooms where people sit in queues. There are lots of call centers where there is no call center. It is lots of folks working in their kitchen or dining room and with a headset, and never, ever, ever see corporate, never set foot on what I'll call company property. That's the archetype of remote. If you have someone who's mostly remote, needs to come in on occasion, maybe the answer in that case, or maybe if I were OSHA, maybe I would be saying, okay, for that person, you don't need to see vaccinated, but they need to come show proof of vaccination. If they're, strike that, I'm going too fast. If they're not vaccinated and they're remote, but they need to come into the workplace for a week, a day, maybe OSHA would probably say they'll have to show a test for that week, but they're not going to have to get tested and show you, for the other 51 weeks of the year, they're not going to have to show you, get a test and send it to corporate and say, hi, you don't know who I am, you've never seen my face, but just so you know, I got a test and I'm negative. That to me might be how that one shakes out, but we'll have to see. The other issue that will come into play is going to be, again, remote work in some instances, it's just simply not a possibility. But during the pandemic, we've had a lot of folks who've worked remotely. As we sort of look at return to work, we've had folks who have been working remotely seek to continue to telework as a reasonable accommodation. Maybe it's because of a disability, maybe it's because of a religion. We have folks who say, hey, I can't get vaccinated. I'd like to continue to telework so that I'm not subject to this. I am sure that you will. We'll have to see what is expected and requested and required of you by the ETS and other federal and state EEO laws.
Great, thank you. And this one's good. How can you verify if someone is truly vaccinated and does not have a fake vaccine card? This almost strikes me like an immigration law question where employees might use fake IDs to get a job in some instances. Well, who has the burden here?
I would expect the I-9 card or the social is a perfect example. I would think if an employer is making reasonable efforts to verify that it's a vaccine card, I don't think the employer is going to be held responsible by OSHA if the employee has gone out and faked one. I also don't know, will OSHA, for purposes of vaccination, will they accept only, we've seen different approaches in different states. Some states are like, show us a picture of a card or a document from your healthcare provider. Others have allowed for what I call employee attestations. I, Jim Peretti, signed under the pains and penalties of perjury that I received my vaccination on X date and Y date. I've recommended that to a lot of clients because, one, you're not getting into medical record retention requirements, but two, at the bottom of that form in big old bold type is, I understand that if I am knowingly providing incorrect information, I will be subject to discipline up to and including termination. If you are going to go the route of saying, show us your ID cards, I think you put that same language when you say, show us an ID card, and knowingly providing a false representation is grounds for immediate discipline. But I think an employer can only do as much as they could possibly do. if I hold up a crayon with a smiley face on it that says vax, probably not okay. If I show you something that looks to me like a vaccination card, looks like every other vaccination card I've seen, I think you're probably in safe ground.
Okay. A couple questions about sort of the reach and the stick behind this regulation, Jim. Will this action have the force of law, or are we talking about guidance here? And if so, what penalties will employers face in this context?
It's because it's an ETS, it's not going to be guidance. It's going to be something with, more of regulation, which, the force of regulatory law. We won't know until we see it, but I've seen reference to, penalties of up to $14,000 per violation. That's probably the furthest reach OSHA can go right now under its existing statute, and that may be where it's a willful violation and a repeat violation. But the short answer is we won't know until we see it. But I can say with relative certainty, this is not going to be guidance or recommendations. It's going to be, we've been doing guidance and recommendations, and obviously, rightly or wrongly, the administration has felt that hasn't been sufficient. So now we're moving to this.
Sort of an OSHA mechanical follow-up. Does OSHA pursue these challenges against potentially non-compliant employers, or who would bring these challenges?
Generally, it's OSHA. You'll have, you may have whistleblowers who report to OSHA, but OSHA enforces the OSHA Act, which is where these penalties would lie.
Thank you, Jim. Do we anticipate any industry exemptions to this private employer requirement?
Industry-wide, I don't, sitting here, I don't anticipate an industry-wide exemption. We've already gone with, we had an industry, the first ETS was industry specific to healthcare. I don't know that I could see a set of facts where an entire industry is carved out. I think more interesting questions will be, I have employees who work on offshore drilling rigs and cannot, depending on what's an acceptable test. If that means I have to send the tests, I have to send the tests. But there are instances where it just may not simply be feasible for an employee to get tested or to get vaccinated. I mean, those are exactly the sorts of unanswered questions we don't know.
Yeah, and I think too, Jim and Mike, I think part of that is coming out because right away on Friday, the postal workers are exempt of all kinds of things, and technically they're not part of the government employee set. So that has started this long conversation about how does one get an exemption as a type of employer when you interact with the public and you interact with each other. How could there possibly even be an exemption? So it'll be interesting to follow this and see, like you said, if you're working from home, but you have to come into a central office for 2 hours a week to drop off or pick up paperwork, whatever, does that put all of that? I think is what we really are going to try to figure out how that's going to work. Are you exempt up to a point, depending on what your role is as an employee inside of an organization?
Yeah, that'll be interesting. I from my gut, Tam, the situation you just described, if I have to routinely come into the office for 2 hours a week, I don't know that I'm ever, it's only 2 out of 40, but yeah, I don't know that OSHA is going to say that's remote versus I don't routinely have to come in. But again, it may be that if that's the case, Jim has to either show vaccination proof or in weeks where he has to come in, show if testing is an option, if testing is something the employer is allowed or required to do as an alternative, that may be, what the answer to that question is. But I would be, I don't know, I'm just speculating. And we have about 1 minute left, Michael, so I want to make sure you have any final questions.
Of course, you heard me at the top say that we're likely to give people back their time. Famous last words. Thank you for all the insights here, Jim. We've got a host of interesting questions here still, but we'll wrap with this one. Just several questions about the viability of this regulation long term. You've mentioned some potential court issues. Do you believe that challenges will be brought? Will parties have an opportunity to bring challenges, and will they have? What will those challenges likely be based on, and have any chance of succeeding?
Predict with certainty there will be. It's an easy question. Yes, there will be challenges. I think there will be challenges from employers and from employer associations, from government. We've already seen, quite frankly, it's become somewhat politicized. It's not somewhat. It's politicized You have governors of states saying we're going to go to court before this ETS even issues to challenge the directive. When the ETS is published, I am certain there will be folks who bring legal challenge to it. Those will probably range from constitutionality to Administrative Procedures Acts, and did OSHA establish a sufficient record to justify this? I am, we will not know until we see it it's the famous question. Can I bring a lawsuit? Can I sue? I'm like, well, courthouse is down the street. Yep, you can sue. Will I win? Harder question. So maybe we'll do that one on V2.
Well,
Awesome.
Tim, it's great to end on a yes/no response there. Give you an easy one after you dazzled us with many, many interesting ways of saying I don't know to these unanswerable questions at this point.
I thought I did a nice job.
Yeah.
Thank you so much to our speakers. We're at the top of the hour, so thank you again to Jim Peretti, Tam Kennedy for all their insights today. We'll send out this recording, and you can look for lots more IFA information on this topic as an emergency temporary standard on vaccines and testing is required. Thanks everybody for joining, and everyone have a great rest of your week.
Thank you.